Welcome to today's webinar on protecting children online. Very important topic for regulatory people, but also for people like me who are parents and are very interested in the topic. So before we get started, I'd like to go over some housekeeping information. So here you have a screenshot of the platform we are using today. As you can see, you can type your questions in the question tab, which is arrow A, and we will try, if we have time, to answer some of the questions, but if not, we will reply as usual by email, probably after Easter break. And well, most probably after Easter break. And in the second tab, so in the documentation tab, you can find documentation, including the slides that we will be presenting today. Just so you know, this webinar is being recorded, and we will share the link to the recording tomorrow morning. Okay, so I will now present to you my dear colleagues. So Elena, who is here with me in Brussels, and Pedro, who is in Brazil. So Elena is our head of global research. She joined Cologne International in 2009, and she leads new service developments and our global trends service. Before joining Cologne International, she worked for Telecom Italia and the World Bank. And my colleague Pedro works as an analyst for the Americas team. He follows the regulatory developments in Brazil, and he previously worked in public policy advocacy and public relations in Congress. So thank you, Elena and Pedro, for being here. One last information. So after the webinar, you will all see a pop-up with some questions, some feedback questions. We would be very grateful if you could give us your feedback. So it will help us, of course, for future events and to know what you would be interested in hearing from us. And we will also plant a tree for each feedback we receive. So please give us a lot of feedback. Voilà, I will now give the floor to my colleague Pedro, and I will come back for the Q&A. Voilà. Good webinar,
Thank you.
everyone.
Thank you, Sarah. Thanks everyone for attending. It's a pleasure to have you here. And I will pass the word to my colleague Elena so that we can begin our presentation.
So, hello everyone. So, as my colleagues are saying, it's a very interesting topic, very hot topic in all parts of the world. So today, what we are going to discuss is first of all why all this, let's say, activity on this topic. It's just, by reading the newspapers, you see a lot of news related with minors online and issues, etc. And let's say that this topic about, how this kind of tools and services affect minors has been really under the radar of academics for quite some time. And here I just wanted, went through some academic studies that were published in the past 5 years. And here I also mentioned some of the academic institutions where these studies were published. But in practice, we can say that the focus of and the findings are can be also very different. On one hand, let's say some academics and health experts, for example, have highlighted that there are some aspects on gaming experience that can really be beneficial for brain performance, or for example, they can improve a certain type of attention, or even help, for example, autistic children build the social skills or build confidence and so on. So there are certainly some positive impacts highlighted by health experts, but also there have been some kind of concerns raised by by academics, for example, associated with pediatric obesity when there are online addictions, or, for example, the unhealthy lifestyles that can be promoted by digital advertising, or some impacts on depression, on behavior, on anxiety, emotions, and even impacts on children's brain and cognitive processes. So there are different type of, let's say, points of attention in the academic field. Then let's say that also in parallel, we have seen increased activity and attention among policymakers around the world. For example, the European Commission has been mapping the impacts of social media and online services on minors, in order to identify risks and benefits and try to maximize the benefits while minimizing the risks. But also, for example, the organization for on the child of the United Nations, UNICEF, has, for example, studied the impacts of online and digital services on education. Also, a lot of interest in from individual governments and authorities about the type of risks and how to address them. For example, in China, there has been quite a lot of studies and government attention on both the physical and mental health issues, as well as how a certain type of services might affect and in the development of values in the young generations. So a lot of studies and law proposals and so it's the topic is couldn't be hotter today, just to say that. So in order to organize in this very short time frame, how this, the regulation and policies have been evolving and in what way, what are the main approaches, we have, with Pedro, tried to identify the three basic ways of regulating the use by minors of online media and gaming, and at the same time we have also tried to make a check of, for example, policies and regulations that are even interfering on the type of tools that are used to ensure compliance with certain rules. And there are two main sides of the story here. On one hand, the regulations can affect directly the online service providers, or the providers, for example, of even device manufacturers. But on the other side, there are, let's say, the impacts and the regulations on that are directly related with the minor activity. So let's say that now we are going to discuss, first of all, the first step. Let's say it's more like an entry-level side of a regulatory approach, and that is about privacy and advertising. So about privacy laws, let's say that we made just a very general overview of the privacy laws that really treat and include the special provisions on the protection of minors that in some laws, for example, are considered particularly sensitive type of data, minors data. There are many different examples, but here what we wanted to highlight is the fact that in some parts of the world, there has been an evolution of the rules. So, for example, when we talk about the Child Online Privacy Protection Act in the United States, this is a very old federal legislation because it dates back to 1998, or even the EU GDPR that dates 2018, that has specific provisions about minors, let's say, are laws that compared with others are more, let's say, rooted in a certain kind of protection and tradition. And well, now the GDPR is under review, for example, but let's say other type of legislation has been introduced afterwards in order to introduce better protection to minors, also from different angles. The same, for example, in in Canada, or in several countries in Latin America, there have been amendments to old privacy rules, and also in, let's say, in Canada, there is a proposal of a specific online privacy code that is still not yet adopted. Then we have, let's say, in several countries, for example, in Africa, there have been some privacy laws that have been integrated by specified guidance on how to really implement and apply the rules regarding minors. And in Asia, there has been a massive amount of activity from the legislative and regulatory standpoint on modernizing regulatory frameworks or making them more effective by the issuance of specific guidelines. That is, for example, in the case of Singapore, where the 2012 privacy law was then integrated by specific guidelines on minors in 2024.
Thank you, Elena. After we've analyzed a few of the privacy rules for minors around the world, I want to speak about restrictions to advertising online to protect minors. And as you can see from the chart, most countries in the Americas do restrict some sort of advertising online in order to protect minors. The type of restriction varies, the content, the advertising content that is restricted vary. However, in most countries that restrict this sort of advertisement, it is the result of general media neutral rules rather than specific rules on advertising online to children. So, for example, it could be the result of a general ban on advertising to children, advertising alcohol products to children, rather than specific rules on advertising alcohol products online. And as we can see, the US does not have federal rules on advertising to children, and the regulator, the Federal Trade Commission, the FTC, has, however, published non-binding guidance on protecting children from blurred advertising. We'll now take a look at a few specific cases, but we can see that in general, countries in the Americas do have certain restrictions on advertising online to children, even though most of these restrictions are a result of media neutral rules. In Canada, the Online Streaming Act recognizes online platforms, including social media and online streaming, as broadcasters. So in Canada, adhering to the Code for Advertising to Children is a licensing condition for broadcasters. And as a result, online platforms are required to adhere to certain rules on protecting children from certain advertisements online. You cannot, for example, advertise online urging children to buy certain products, or even asking their parents to buy these products or services. These are some of the rules that apply to broadcasters online, to online platforms, as a result of the self-regulatory initiative, which is a licensing requirement in Canada. In Brazil, the recent digital statute of the child and adolescent forbids online platforms from delivering targeted advertising to minors. So online platforms cannot process data from minors with the goal of building a profile and delivering targeted advertisements to users based on this profile. Additionally, platforms cannot take advantage of a minor's lack of judgment to sell them digital services. In the US, uh, although there are no federal rules on advertising to children, uh, COPA, which Elena has spoken about, the Children's Online Privacy Protection Act, does apply. And this means that online platforms need to be careful to comply with privacy rules while delivering targeted advertising to minors. For example, COPA requires parental consent in order to collect and process data from children under 13. And for example, in 2019, Google and YouTube settled a lawsuit from the FTC, which claimed that they violated COPA rules by collecting data from minors under 13, accessing and using YouTube, and using this data to build a profile of the users and deliver targeted advertising to these users. So even though the US does not have federal rules on advertising to children, online platforms need to be careful to comply with privacy rules if they want to deliver targeted advertising. We've now talked about privacy and advertising to children under stage 1 regulations. Now I want to go over a bit a more intense regulation, a stage 2 regulation that we call guardrails, which looks to deliver a safer experience to children online by setting up barriers and trying to deliver a safe environment. So what are the key aspects of these regulations? They impose obligations on platforms, and they create certain restrictions, for example, on content, with the hopes that what remains, the digital environment that online platforms offer to children, is safer and better for their users. These regulations are often complex because they delve into content regulation, content moderation, algorithms, and as a result, jurisdictions across the world have landed in significantly varying rules to try and create these barriers. So we'll now take a look at a few of the jurisdictions to understand similarities and differences in the rules, in how they try to deliver this safer experience to children online. As we can see, we've selected 4 jurisdictions, namely, we want to take a look at Brazil's recent digital statute of the child and adolescent. They use Digital Service Act, Malaysia's Online Safety Act from 2025, which also shares a name with the UK's Online Safety Act. And when we compare the scope to which these rules apply, we can see that countries adopt different rules. While some apply equal obligations to all providers of services, online services likely to be accessed by children, other countries impose obligation that cascade either according to the type of provider, as we can see in the UK, or even the size of the provider. In the EU, the DSA imposes additional obligations on very large online platforms, while Malaysia's rules only apply to platforms with more than 8 million users in the country. And if we take a look at the guardrails that each of these jurisdictions impose on the content that online platforms may offer to children, we can see that the EU focuses on risk assessment and mitigation. So the DSA imposes on online platforms a general obligation to ensure that their services are private, safe, and secure for children. And in 2025, the EU Commission published guidelines with a detailed list of how should online platforms comply with this general and broad requirement of privacy, safety, and security for children. In other jurisdictions, for example, in Brazil and in Malaysia, we can see that there is a general trend of imposing a broad obligation to prevent access to harmful content. So these jurisdictions require online platforms to deliver only age-appropriate content to children. Talking about parental control tools, we can see that Brazil is the only jurisdiction to rely on this tool as a mechanism to ensure and deliver a safer digital experience to children. In Brazil, the law requires providers to offer to parents tools which allow them to monitor and control their children's usage of the online services. Malaysia and the UK do not have rules on parental control tools, while the EU does not impose a general obligation of offering these tools, but rather requires that online platforms conduct risk assessment, and guardian tools are recommended as a risk mitigating measures in face of possible harms that could be present for children in these services. Finally, when we compare fine amounts, we can see that the EU and the UK have set a maximum fine amount based on global turnover, while Brazil sets its maximum fine amount on turnover on revenue in Brazil, which might significantly impact fine amounts in Brazil's legislation. Malaysia does not have specific rules on fines for violating the rules on protecting children online. In conclusion, what can we see is that different countries and different jurisdictions have adopted different strategies in trying to deliver a safer experience to children online. For example, the EU focuses heavily on risk assessment. Rather than imposing cookie cutter and obligations, which apply across different providers, which offer significantly different services, the EU requires online platforms to conduct risk assessment reviews, and as a result of these reviews, implement risk mitigating measures. Brazil and Malaysia, for example, impose a general obligation to prevent access to harmful content. Also, when comparing these, when looking at these rules in conjunction, it's interesting to think about a platform or a service which offers services across all of these jurisdictions. And we can see the complexity and the challenges in stage two regulations. Uh, a platform which offers its services across all of these jurisdictions needs to be mindful of scope of obligations, nature of content moderation obligations, and more in order to ensure it is compliance with the rules in all the countries. So really, this comes down to complex rules and complex compliance. And finally, I want to talk a bit about the US. You might have recently seen a few headlines on landmark cases regarding online platforms and damages to minors in the US. And maybe you've wondered, does this mean a change of environment, a turning page in the US policy environment for online platforms? And what I want is to quickly present what we can and cannot say based on these decisions. Really quickly, what were the cases? Firstly, a private party in California sued Meta and YouTube and was awarded $6 million in damages after demonstrating that these platforms were negligent and that their product, the services they offer, was defective, and as a result, caused damages to the minor. In the state of New Mexico, the state directly sued Meta on the basis of state consumer protection law, and Meta was found to be in violation of this law and was sentenced to paying over close to $400 million in damages. What can we be certain of regarding these cases? First off, they are still ongoing, so we cannot be sure of the final outcomes. The platforms are expected to appeal the decisions, and it could take years before a final decision is reached. Despite that, we can say that these are landmark cases, particularly in California, because the private party was able to go around the broad safe harbor regime for online platforms in the US under Section 230 and was able to demonstrate damages not as a result of third-party content, but rather as a result of defective services that these platforms offer. And finally, it's also important to note and have clear that these cases do not mean a policy change or generally enforceable rules in the US. They are significant and important, but they apply only to the parties in the decision and do not mean new rules in the US. What will still remain to be seen is first, how will the cases end? What will be the final decision after appeals? Secondly, will more lawsuits follow? So will more private parties be willing to sue these platforms on the basis of the same legal arguments which the private party in California used to receive damages from the online platforms? And if so, will online platforms change their practices in the long run? These are important questions, and answering these questions in the long run might give us a broader picture of how these decisions, how these cases could affect the US policy environment for online platforms. Now I'll pass it over to my colleague Elena so that she can talk about stage 3 regulations.
Okay, so stage three is a different type of approach because it really is about really directly restricting access from minors to certain type of platform services. And here we go closer and closer, let's say, to the situation of of the end user experience, really, because the restrictions are imposed on the user side of things. So there are a few examples, and I think the most relevant one is probably also because it was imposed quite a long time ago. In China, it was initially imposed on gaming activity by minors. In practice, the objective here was really to avoid, to curb minors' addiction to online gaming, because they were having some adverse impacts, for example, on the educational performance of pupils. And in China, they were among the first to start observing, the impacts on the physical and mental health of minors of this type of platforms, and their risk of addiction. And so let's say that China started restricting, really imposing access limitations in terms of time. For example, when minors and adolescents could play video games, and they restricted it to 90 minutes on weekdays, and then 3 hours on weekends, while and also banning completely the activity from 10 p.m. until 8 a.m. in the morning. So that was, let's say, really a straightforward access restriction that was imposed. Then this restriction was amended in 2021, so the rules became even tighter. So the maximum amount of time was lowered significantly. And this type of access restriction in 2023 was even extended beyond online gaming to include all other type of live streaming platforms, like, for example, video sharing sites and social media. So at the end of the day, the situation in China is that providers must strictly implement users this restriction, also by verifying, let's say, who are the users of certain online services. And they have even strict real name verification and identification systems to make sure that the minor doesn't circumvent the rule. So it's really a kind of direct access restriction. Another restriction is in Australia. We have read extensively about the outright ban that was imposed on social media users under 16, and the legal basis for that was amendments to Online Safety Act that were introduced in 2024, and then let's say the restriction came into force in practice in mid-December last year. Let's say that these rules include a number of exemptions. So, for example, minors under 16 can still use messaging services, online gaming, and also other services that are health and education related. But at the same time, it's also it's important because the rules here are not as prescriptive as they are, for example, in China. Because in terms of implementation, online platform providers must take what the law called reasonable steps to carry out this goal of taking minors under 16 off social media. And eSafety, that is the authority in Australia that implements the act, issued in September, so 2 months before, 3 months before the implementation of the restriction, some guidance. And this guidance includes some reasonable steps that should be followed by social media platforms in order to ensure the implementation of these legal requirement. Let's say that outright bans on social media have also been imposed or are in advanced stages of discussions in several other countries around the world. Let's say that, for example, in Ecuador, there is a reform of the Children and Adolescents Act that is currently under debate, that if approved would impose a restriction for minors under 15. This is something that is also at various stages of discussion or adoption in EU member states. And here I'm not going to deep dive into the many different approaches and debates that are taking place in EU member states, but because we will have at Callen International a specific training initiative later in April, and so that will be discussed by our European media experts. But this is just to say that there are several EU member states that are really considering imposing restrictions similar to those imposed in Australia. Also, this is under discussion in India, it's under discussion in Norway, in the UK. In Indonesia, they have really passed a new regulation. I mentioned briefly in my slide on privacy rules evolution, because this regulation 17 of 2025, which will be enforced from 2027, so it will take 2 years for it to become fully effective. It's interesting because it imposes different type of restrictions and safeguards and guardrails based on age. So it's really tired based on the age of the minors, and so the younger the minors, the higher the restrictions, and so it's quite an interesting piece of legislation. And also Malaysia passed a restriction for minors under 16, like in Australia, but as opposed to Australia, the regulator that will implement these rules has not yet issued specified guidance on how these type of restrictions should be implemented. And here we come to probably the most challenging part of all these rules, that is really about ensuring compliance, because we have seen different grades of regulation, different approaches, different type of measures in different parts of the world. But at the end of the day, what is really important is to understand a bit what kind of tools are being put into place to ensure compliance. So there are two main types of tools available or under consideration in many cases to ensure compliance. And one is really about how to effectively check age online remotely, because there are many different ways to circumvent sometimes the measures by using, for example, certain type of tools, or simply by pretending or using age assurance methods that are not sufficiently adequate. And indeed, there are two different terms to really to check age remotely. One is called age assurance. That is something that is based on an approximation of the age of the user. So, for example, by using a picture, or by other methods that can somehow are considered less accurate than age verification as such, when you have a certain system that allows the online provider to really ascertain that what is the exact age of the user that wants to access certain type of content or services. A second type of tools is really by directly preventing or blocking access. And this can happen really by using measures on, for example, on the handsets, on the devices that the device is, or devices that the user is using to access these online services. So, checking age remotely, there have been some, debates recently about what is the best methodology and what are the tools to be used to ascertain age online. And as I said before, eSafety provided some guidance, and in its guidance, for example, it specified the measures that they would deem insufficient, they would deem ineffective, not sufficiently effective. And but there was no prescription about, for example, the technical and organizational ways to check precisely online age. And let's say that in the UK also there has been there has been a consultation by Ofcom in order to to really study and understand what type of measures could be put in place by providers to verify the age of users seeking access to certain content. But also in this case, this is really left to the solution that the providers deem appropriate. So Ofcom published some guidance, specified possible methods, and even specified methods that it would deem more effective than others. While, for example, in Brazil and Malaysia, they're still studying what is the methodology and what could be the appropriate tools, if any. And in China is the only jurisdiction that we know where there is really a strict name registration requirement, where there must be age assurance check and authentication methods that are approved by authorities in order to for providers to comply with their name verification and registration requirements. On top of that, in China, the Cyberspace Administration issued rules in 2024 about, how to prevent minors to access certain type of content and services. And in practice, they have implemented what they called this minor mode. That is a type of, let's say, feature that is included in the devices. So it could be a smartphone or tablets, for example, that is turned automatically on when, let's say, this a tablet or a smartphone, for example, is purchased for a minor, or let's say in any case only parents or guardians are those who are entitled to deactivate certain features. And what is also interesting to note is that this minor mode includes a number of indications about, the timing, for example, restriction. So in the platform, you also have some kind of guardrails already included, already embedded, about also the type of content that is appropriate or not appropriate. So the not appropriate one is automatically blocked. So these are the kind of measures that providers, including manufacturers, but also the online service providers must include. And so that is something quite interesting, and we even issued some specific research about this at Callen International. Another approach is interesting because it's not really directly stemming from a regulation. This is more like a measure that was recently adopted by Apple, so a very important device manufacturer, in ensuring, applying some Apple account settings that are approved, let's say, are based also on age. So that means that, for example, in some jurisdictions, including the UK, and this was also covered recently in several media, in practice they are confirming the age of the Apple account users, and in practice, if the age is not verified in practice, certain type of services will be disabled. So there must be some kind of interaction between the provider and the user in order to set up, let's say, the requirements and of also based on age. And we see that similar type of restriction are, for example, implemented right now in Singapore, in South Korea, and this is a way of, let's say, providers to somehow having some kind of self-regulatory approach, I would define it, in order to make sure that rules that exist in the protection of certain type of users can be correctly implemented without causing, let's say, problems. So it's also based on the good dialogue that might exist between regulators and online providers or device manufacturers in this case.
Thank you, Elena. And getting ready to wrap up, first, we want to take a look at key takeaways of the presentation, a quick summary of what we've discussed. First is that, as we've seen, authorities around the world act as a result of perceived risk. So the more they understand that the online environment offers risk and harm to minors, the more willing they'll be to regulate and regulate more intensely. And the recent wave and rise of AI generated content add complexity to this analysis and may even add fuel to the fire. Additionally, challenges like the ones we've discussed are becoming global, and therefore laws might have extraterritorial implications. Finally, rules across all stages of regulation face technical implementation challenges. As Elena has said, we've discussed privacy rules, advertising restrictions, guardrails to deliver a safer online experience, and access restriction under certain ages and to certain types of services. All of these rules, regardless of how intense they are, uh, depend on technical implementation details to ensure that they are effective in delivering a safer and better online environment to children. Thank you.
Thank you so much, Pedro and Elena. It was super interesting. Just we have one question about access to the recording of the webinar. We will send an email tomorrow with the link, and it will also be on our website. It will just be done tomorrow morning, so you will have all the information. Don't worry. Also, the slides will be sent to participants, and but you can already download the slides in the documentation tab. Just one quick, I think we have maybe time for one question. I think Elena, perhaps a question for you. So do you have any examples of regulations addressing the risk and potential impacts on minors in the increasing use of AI? Pedro just mentioned AI. So
Okay, so let's say that we can say there are a few examples, but we can highlight first of all a general tendency, as was said by Pedro. There is an increasing tendency also to upgrade existing regulations on the protection of minors or even on privacy, also because of certain impacts and risks that are observed by the development and increasing use of AI. We have seen, let's say, this tendency very recently with for example, the dissemination of certain, nudified portrait, for example, of children, or the use of AI for pornography, etc. So this, of course, has, in many respects, accelerated and put a lot of pressure on legislators in different parts of the world to update their regulation and to impose a better and more effective, control over these type of risks. Having said that, there are several, let's say, on one hand, as regards AI, we have regulations really specifically regulating AI are very rare. We have several, for example, even the AI Act in Europe addresses different type of risks. So I would say that considering that risks like, for example, offending the dignity of people, for example, or unauthorized sharing of images, of intimate images, or facilitated by AI and so on. So these are very delicate risks associated with the usage of AI. And of course, this is one way of seeing how AI enters the picture in this type of discussion. On the other hand, there are also, for example, this debate on has created a lot of concerns in countries that perhaps regulate the protection of minors online, but not from the perspective of AI. And so, let's say, there have been recently some public consultations, for example, in the UK on, but even, the introduction of this statute of online protection in Brazil is the evidence that recently also the impact of AI is felt in all the the laws and regulation that more broadly aim at better protecting minors. In China, there are specific regulations on AI, even specific regulations addressing different type of uses, including, for example, on generative AI. It's been the first country in the world to regulate generative AI. So it's let's say that, of course, a certain type of outcomes are completely prohibited, are considered illegal content. In other parts of the world, there is the need to really mediate between, on one hand, the concept of free speech, of the safe harbors that exist in the circulation of online content, with the obligations that already exist about notice and take down. So this is why, first of all, this topic is extremely complex to tackle. So that's why we used this very simplified categorization in describing a bit the type of approaches and tendencies. But also, it's something that proves that is a fast evolving topic where it's very difficult to predict today how legislations are going to evolve. And this was remarked, for example, by Pedro, because it really depends on the outcomes of important cases, and how society and policymakers will feel about this topic. If it if it becomes hotter and hotter, we could expect intervention.
Yeah. Thank you, Elena. And just one last question. We still have 3 minutes for Pedro. So the question is, are you aware of any regulatory frameworks or legal precedents specifically regulating autoplay features?
Yeah, so I'm aware of two examples. Malaysia's Online Safety Act, among other things, require online platforms to limit the features that extend a children's usage of the service. So depending on implementing regulation, we can see how that could impact autoplay features. Also in Brazil, this sort of feature is expected to be part of parental control tools, allowing parents to control sort of the behavior of platforms. And one of the measures in the law is to adopt the most protective configurations by default. So, for example, parents would be allowed to control features like autoplay, rewards after using the service for a certain time, notifications, and other features that could extend a minor's usage of online services. All of these features should be controlled by parents and disabled or limited by default.
Well, thank you, Pedro. I think we will stop here because we have only 1 minute left. As Elena mentioned, if you want to go deeper into the topic, but more on the European side of things, we will have a very interesting online training on 23rd of April. You can find all the information on our website, and there it will be more about the different approaches of EU member states. Why are they going their own way? And so 23rd of April, and you can still register to that training. And for the rest, well, thank you very much for being there today for this very interesting and important topic. And don't forget to give us your feedback, very important too, because it really helps us. And yeah, see you at future events, and Voila. Send us your questions too if you want, if you have other questions. And for the questions we didn't answer, we will reply by email. And I think that's it. Well, thank you, Elena. Thank you, Pedro. Have a nice day. For us, it's the end of the day. Voila. Thanks, everyone.